Hello everyone, so this is going to be your civil rights track argumentative essay. This is going to be me live writing that essay. Oh, I need to have my mask on as I'm sipping coffee. And so here's your actual AP government review. So you can see right here, develop an argument that explains which of these three forms of action taken by the federal government, constitutional amendments, Supreme Court rulings, or legislation has best ensured the civil rights of minorities and historically repressed groups. So this is where I'll be writing it. So in keeping with my recommendation, so as you're reading the prompt, make sure you're circling important task words in the prompt. So maybe an argument, or not develop an argument, but circling important task words. And then I am definitely going to argue that constitutional amendments have best ensured the civil rights of minorities and historically repressed groups. I'm sort of making an argument similar to one that conceivably if Eric Foner, he's a historian at Columbia University, and I'm going to put a video in the description, this video specifically from the Chicago's Humanities Festival, that really kind of argues, or is kind of like the definitive historian on Reconstruction, and specifically he sort of, or not he sort of, but specifically we can think about the significance of the Reconstruction Amendments, the 13th, 14th, and 15th Amendments to remaking our republic, remaking our constitutional system, for establishing general principles that become litigated and interpreted by courts, and sort of bases for social movements that emerged in the 60s. So you're not going to be given this many options for evidence as you are in AP, or in the actual AP exam, but I gave you tons of options because obviously, number one, I wanted you to kind of know what you needed to know on the test, right? You're only going to have to choose 2 pieces of evidence for this essay, but you should be able to, or you should go back and review all these other Supreme Court cases, foundational documents, or constitutional amendments, which are the types of evidence that you can use in an AP government essay. And so I'm going to run through all of this, like bits of evidence, and sort of model what you could potentially do on the test. Yours is, you're not going to say it or necessarily, don't waste tons of time on the test, but I would recommend jotting notes next to foundational documents or constitutional amendments that you kind of recall, just so you don't forget them and are able to eventually apply them or integrate them in your essay, right? It's not going, your essay is not going to be as complicated as mine because I'm going to try to use as much material as possible because I also wanted this to be a content review for you guys. Right, so I'm going to try to use as much evidence as possible and try to convey a lot of ideas. So my thesis, my essay is going to be much more complicated than yours will be. And so articulate a defensible claim or thesis that responds to the prompt and establishes a line of reasoning. So Federalist number 70, so let's go ahead and go through the evidence. Federalist number 70 was written and it argued for a strong unitary executive because there was a constitutional debate about whether the executive branch should be comprised of a council of people that would deliberate how best to execute the laws that Congress passed, or whether it should include a just a single executive, right, a president of the United States. So in Federalist 70, there's this argument for a strong unitary executive. And the way that this is going to relate specifically to this whole essay about civil rights, well, we can take it in the direction of, or we can think about how important the Department of Justice becomes, for instance, in enforcement of the Voting Rights Act, which is going to be another piece of evidence that you can see here. The Department of Justice becomes this really important player in this enforcement of the Voting Rights Act and expansion of suffrage to African Americans in the South, specifically, where there's a whole variety of practices meant to sort of inhibit African Americans from exercising their right to vote. So the whole argument by why you would want a strong executive as opposed to a council of executives is that a strong executive can get stuff done, right? They're able to act with intention. They're able to set things into motion much faster than like a deliberative body like Congress can do, right? And so Congress is structurally a deliberative body, one that, especially the upper house, or not especially the upper house, but it's structurally a deliberative body that moves a lot slower than the executive branch, and that is sort of by design in some sense, right? The executive branch is supposed to be, according to Hamilton, it would be advantageous if the executive branch moved with speed. Of course, the alternative arguments would be like this could lead to tyranny, right? Sort of, states' rights types of arguments that might emerge in Brutus #1, which is another foundational document and foundational text that we should know and is a required foundational document. But again, the challenge of this essay, or not again, the challenge of this essay is to take these documents, these foundational documents that either have arguments embedded in them or sort of general principles or are laws or major statutes or Supreme Court rulings and holdings with significant, obviously, implications, to take them and apply them to contexts that may not apply them to outside contexts or contexts removed from the context in which they were written, right? So that's always a challenge, but we can find a way to, right? Federalist number 70 is probably a bit harder to make that application and make that leap, but we can definitely do that. Article 3 of the Constitution, remember Article 1 talks about the powers that Congress has, the legislative branch. Article 2 is the president or the executive branch. And Article 3 talks briefly about the courts. We're not going to go into length about Article 3 because it's very brief, doesn't communicate a lot of important details, but nonetheless, we could conceivably imagine how courts, we could talk a lot about courts in terms of advancing rights of minority groups and historically repressed groups. The Declaration of Independence, we all know that phrase, we are all endowed by our Creator with certain unalienable rights. We read an essay at the beginning of AP Government that talked about how the rhetoric, right, the ideals of the United States were not being lived up to. That was the argument in the essay, and that historically social movements that aim to advance civil rights have cited certain key phrases from the Declaration of Independence or even the Constitution to sort of highlight the ways in which American political system has not lived up to sort of its ideals, right? And so we can imagine that becomes an important text in this context that we can apply because of its the ideals that are historically appropriated kind of has a negative connotation, but historically used by social movements to advance civil rights. And then letter from a Birmingham jail, I have that quote, "One has a moral responsibility to disobey unjust laws," at the top of my whiteboard. It's one of my favorite quotes. It's one of my favorite foundational documents. And in the foundational documents, Martin Luther King says there's a distinction between just laws and unjust laws. One has a moral responsibility to disobey unjust laws. And then notably, in Letter from a Birmingham Jail, MLK talks about how segregation laws are unjust laws and therefore should be disobeyed. But like the Brown versus Board of Education decision, which the South is not adhering to, is an example of a just law. And then in Federalist 70, Hamilton sort of makes this argument about the courts, right? He makes this argument about the important role that the judiciary can potentially play and kind of endorses this idea of judicial review. So specifically, he suggests that the judicial branch is probably less prone to being tyrannical because Congress has the power of the purse, right? They have the ability to appropriate funds. The executive branch has the power of the sword, right? The president is commander-in-chief of the military, and judicial branch really doesn't have much, but it kind of endorses this idea that justices in our system should serve for life because they will be less susceptible to political whims and pressure, right? And they can more accurately apply and interpret the Constitution and more accurately apply laws in general. And then it kind of endorses this power of judicial review, which we say kind of takes off with the Marbury versus Madison case, which is this special power that courts have not only to apply the law or to interpret the law, but also to determine whether a thing is a law at all, right? This is this incredibly strong power, right? It's this ability for the judicial branch to say that executive action taken by the executive branch or legislative statute, so a law passed by Congress, is in fact not a law, is not lawful because it's unconstitutional. Right? That's a very important power, and the only way that, of course, that you can sort of overturn a Supreme Court ruling is through a constitutional amendment. Finally, we use a second piece of evidence from the list below: Voting Rights Act, 14th Amendment, Plessy versus Ferguson, Brown versus Board of Education, Korematsu versus the United States, 13th Amendment, 15th Amendment. Finally, we have the some other major pieces of legislation. So I would go back and look at the Civil Rights Act, the 1964 Civil Rights Act. It's an incredibly important piece of legislation. I'm going to talk also about the 1965 Voting Rights Act, which through Section 2 of the Voting Rights Act. Let me look at the specific language, see if I can pull it up. Let's see. Yeah. Section 2 of the Voting Rights Act says no voting qualification or prerequisite to voting or standard practice or procedure shall be imposed or applied by any state or political subdivision to deny or abridge the right of any citizen of the United States to vote on the account of race or color. So importantly, Section 2 of the Voting Rights Act outlaws poll taxes and literacy tests, which essentially become the mechanisms by which the southern states deny African Americans their ability to exercise their right to vote that is given to them in the 15th Amendment. Right, so let me see if I can find the 15th Amendment to kind of compare the language. You can see the language is similar, but the 15th Amendment has one important workaround. Let's see, okay. So the right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on the account of race, color, or previous conditions of servitude. So this amendment was passed in 1970. But, however, importantly, although it bars states from denying anybody the right to vote based on race, there are other ways, and historically, southern states adopted a series of Jim Crow laws and other mechanisms that were on the face of it race neutral, right? Like literacy tests or poll taxes to deny people the right to vote, and of course those disproportionately affected African Americans. So the Voting Rights Act in some way kind of gets around this workaround, right? Outlaws poll taxes, outlaws literacy tests, and also does a variety of different things. It gives the federal government much more power to exert and it gives the federal government significant teeth in sort of ensuring African Americans have have a right to vote, right? So Section 2 of the Voting Rights Act does that. Famously, it also requires that certain states, Section 5 of the Voting Rights Act requires certain states seek pre-clearance, like go to the Department of Justice, either through the Department of Justice or a federal court, before they change a law, before they change a voting law. They have to actually seek pre-clearance. And then Section 4B gives the formula for states that are subjected to pre-clearance, and that includes, but is not limited to, whether the states, let me look specifically. So that would include a history of Jim Crow laws, right? So a history of Jim Crow laws and discriminatory laws might be sort of the formula that could be used to determine whether states need to seek pre-clearance. What else does the Voting Rights Act does? It allows for federal examiners to actually go and physically register, or federal examiners to go into southern states and register Black voters. It really is this important act that has significant, positive effects in terms of expanding suffrage to African Americans. I'm sure I've ignored some provisions here, but I'm trying to move very fast. And then finally, the 14th Amendment, it has all sorts of general principles. Those are, it's kind of vague principles, and the ambiguity was intentional. It was intentional ambiguity. The principles, there's this great book by Eric Foner, so I kind of introduced him, called The Second Founding, that talks about why so many ambiguities, because there was this expectation that future or posterity would breathe life into these general principles. But in the 14th Amendment, we have the Equal Protection Clause. We have the no state can deny citizens the Due Process Clause. It talks about birthright citizenship. It says that as long as you are born in the United States, you are a citizen of the United States. This is a radical provision of the 14th Amendment that upsets the sort of racialized notion of citizenship that existed before the 14th Amendment. But of course, Supreme Court interpretations of the 14th Amendment do matter, right? And so famously, Plessy versus Ferguson and Brown versus Board of Education are two such court cases. You can talk, but lower. Two such court cases that interpret the Equal Protection Clause of the Constitution. So in Plessy versus Ferguson, it says that racial segregation does not violate the Equal Protection Clause of the Constitution. And let me actually show you these clauses, right? So we can look at these, check these out. So it gives birthright citizenship. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States who birthright citizenship and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. This becomes less a relevant clause because of the Lochner cases and Supreme Court interpretation. So we can actually think of like the Supreme Court, and Eric Foner in the lecture that I'm going to include in the description use the Supreme Court as sort of an inhibitor, or sort of kind of being a spoiler of the racial progress that is promised in these amendments, right? These general principles, sort of taking, or due to judicial racism and a deep-seated suspicion of allowing more and more national power in the federal government at the expense of state governments, kind of being a spoiler, playing the role of spoiler to the promise of these amendments. And then it says, nor shall any state deprive any person of life or liberty or property without due process of law. That due process clause becomes incredibly important with the foreclosure that the Supreme Court places on the Privileges and Immunities Clause. We can talk more about that later, but this is probably the most important clause. There are equal protection claims that are constantly being made, nor to deny any person within its jurisdiction the equal protection of the laws. Obviously, there's a lot of question. These are very vague amendments. There's a lot of questions about the meaning of these terms that one can make, but also we have to also recognize that the language is race neutral. So this would eventually allow for the expansion of these amendments, or specifically like the Equal Protection Clause, the expansion of rights to historically repressed groups. So I'm thinking like gay marriage, like in the Obergefell decision, which is an equal protection case as well, right? So a lot of implications about this, but nonetheless, the Supreme Court had a very restrictive interpretation of the 14th Amendment. They said early on in Plessy versus Ferguson, which was it happened in the 19th century. When was it? Oh my God, so it's so dumb. When was the Ferguson decision? Plessy versus Ferguson. 1890 something. That racial segregation does not violate the Equal Protection Clause of the Constitution as long as it was separate but equal. And then in Brown versus Board of Education, it talks about, or Brown versus Board of Education finally overturns in 1954, right, with the Warren Court, which is known to be a very sort of progressive court, finally overturns the Plessy versus Ferguson separate but equal doctrine. They claim that it's violative, separate but equal, or segregation is inherently unequal, violative of Equal Protection Clause of Constitution. They were specifically concerned in that case with laws mandating racialized segregation, but also we have a Supreme Court that in Korematsu versus the United States, enables, as Roosevelt's internment of Japanese Americans is okay, right? And then 13th and 15th Amendment, I already talked about it at the beginning. The 13th Amendment abolishes slavery. And then the 15th Amendment, to make sure I get all this important things in, bars states from denying anybody right to vote based on race. And then we said that there was various workarounds for that. You don't really need to know this, but historically, and I'll include a link in the description, historically courts, perhaps due to judicial racism, or probably due to judicial racism, and then again, a deep culture and a belief that was suspicious of giving more and more power to the federal government, right? We can see, for example, in the Bill of Rights, it says Congress shall make no law that should do certain types of things, but in the Reconstruction Amendments, it talks about restricting states, right? And so the Reconstruction Amendments are sort of it seems, more and more power to the state or to the federal government at the expense of the states, right? So this culture of suspicion in the centralization of power in the federal government perhaps also contributed to a slew of Supreme Court cases that sort of narrows, where it seems kind of plays spoiler in some sense to the promise that these Reconstruction Amendments have. So I'm thinking specifically, let me list them off. These are not required Supreme Court cases. The slaughterhouse cases, which I talked about, which kind of forecloses the ability of courts to kind of articulate what the Privileges and Immunities Clause of citizenship actually means. What are those privileges and immunities? In U.S. versus Reese, it's which interpreted the 15th Amendment in 1876, they denied disenfranchisement on the basis of, they said that the 15th Amendment only denied disenfranchisement on the basis of race. There are other workarounds that became proxies for race, like literacy tests, that were okay based on that Supreme Court interpretation in that case. In the civil rights cases in 1883, the Supreme Court said that the 13th and 14th Amendments didn't apply to private individuals, that they only applied to states. I talked about Korematsu versus the United States and stuff like that. So we can see that this SCOTUS plays sort of a spoiler in that sense. All right, so that would be part 1 of the video where I break down all of the evidence that you could potentially apply. And then part 2, I'll write my essay.